Hey everybody, News Now Wyoming here. Today we're going to be looking at a case. We'll be looking at video from the hearing itself in front of the Ninth Circuit Court of Appeals, and then we'll be looking at the decision made by the Ninth Circuit Court, and we'll have a little discussion. This is a child protective case, which normally falls a little outside of what we talk about, but this is perfect for what we have been talking about on this channel, which is qualified immunity and absolute immunity. When does it fall into place? When doesn't it fall into place? So I thought that this here really does circle everything around exactly what we've been talking about and finding out what behavior is so egregious it might fall under Hope. So Hope was that Supreme Court decision that said it's just common sense that what they did was wrong, and they knew that what they were doing was wrong. So let's get right into this. I am going to be skipping around in the video.
May I begin?
Yes.
Thank you, Your Honor. Good morning. May it please the court. My name is Pansy Lynn, and I'm here today on behalf of appellants and defendants in the underlying matter, Marcy Rican, Elaine Wilkins, and Helen Dorjak by and through her estate. If I could reserve...
Okay, really quick, some background on this, because we really don't get a lot of background that we're going to be listening to today. So, in this case, Presley Hardwick versus Marcia Rican, a Child Protective Service worker maliciously, these are the court's words found in another different case, that she maliciously created evidence, lied under oath, and just fabricated all kinds of stories to remove this child, Presley Hardwick, from her mother's care back in 1999. I believe it was 1999, or something like that. It's 2000, I apologize. And she was actually removed from her mother's care for 6.5 years. Her mother successfully sued the county in a separate lawsuit and received $85 million judgment from the jury. Then after appeals and a settlement, it was reduced down to just under $10 million. So the family's already received $10 million for the same case. Again, this Child Protective Service worker fabricated evidence.
2 minutes for rebuttal. Thank you. The facts underlying this case are many and sordid, and I won't go through them. Surprised that there was a divorce. He divorced into juvenile dependent custody of 2 daughters, was ordered removed by the Juvenile Dependency Court from their mother. These 2 daughters were Kendall and Presley Hardwick. Presley Hardwick is the plaintiff in the underlying action and the appellee here. Fundamentally, this appeal presents 2 issues: whether the individual defendants were entitled to qualified immunity for their actions, and whether they were entitled to absolute immunity for their actions, or for the actions that they are being sued.
Are you seriously pressing absolute immunity? It wasn't pressed at all in the state. Are you serious about that, or are you going to waste time with it?
I am serious. I certainly would not bring an argument to this court that I'm not serious about. I am serious about the argument because there are fundamentally acts for which our defendants are being sued, the social workers are being sued, that I believe come squarely within absolute immunity.
Okay, so really quick, this is that absolute immunity that we discussed about with prosecutors. Now, Child Protective Service workers, they act as both a prosecutor and as an investigator. So what acts they do as an investigator and what acts they do as a prosecutor, one is they receive qualified immunity. The other, they would receive absolute immunity, prosecutorial immunity. And so this judge here is saying, don't bother making this argument. And we'll look at the argument actually there in the opinion when we get to the opinion.
I understand that qualified immunity is the issue here for substantively the removal pursuant to the court order of...
Why don't you go to qualified immunity?
Of course, Your Honor.
We have your briefs on it.
We don't even want to hear you talk about absolute immunity. We've read your words. Shut up. Move on. Now, I do want to point out that this attorney did an amazing job of taking the facts that she's got in front of her, bad facts, and trying to answer the case. She is, you'll see, she is attacked by, I wouldn't say attacked by the judges per se, but at the same time, under the grilling that she receives from these judges, these 3 appellate court judges, and she does an amazing job under that pressure. She sticks to what she says, whether or not she's right, and she continues hammering her points along. So kudos to this attorney. She is an amazing attorney. I wish her all the best. I hope she is doing well. She did an amazing job under a very tough case where the facts were certainly not on her side.
Absolutely.
Thank you, Your Honor. In terms of qualified immunity, as this court is aware, it's a two-prong analysis. The first being whether there is a constitutional rights violation that has been alleged, and the second prong being whether the constitutional right is clearly established, such that our government actors know without doubt that what they are doing would be a violation of the law. The court is entitled to take these prongs in any order it perceives, and here, typically when we have the qualified immunity analysis and whether the law is clearly established, it is typically plaintiff's burden to come forward to this court and say, here's the case law. This is what tells the state actors, the government actors that.
So she is saying here that there has to be case law for qualified immunity to come into play. Was there case law saying what that this person did was bad, that they were under, that they clearly knew that qualified, or that they what they were doing was bad? Again, this person lied on the stand. This person lied in documents. This person lied continuously, and that resulted in a child being taken away from her parent for 6.5 years. Actually, 2 kids. This is just one kid suing. The other kid also sued, but the case was dismissed she dismissed her own case in 2014. I don't know if there was a settlement there or if it was just she just decided to give up on it.
They should have known better. It's clearly set forth in this case law. In our matter here, it's interesting because the reverse has actually happened. This court has actually found that as of the date of the underlying conduct here in 2000, when
You're talking about Costanich?
that is correct.
Costanich deals with foster care licenses and guardians, not natural children of parents.
Okay, so this is a very, very important distinction. This case that she talks about brings up, and we'll look at it briefly in the opinion piece, or in the court opinion. Costanich itself, they said that a foster care parent has no legal rights, has no constitutional rights in relation to that child. And that child has no constitutional rights to stay with that foster parent. I can easily see that argument. And so any harm that is done that violates your rights, well, it's not really a constitutional violation because you don't have those rights to begin with. Whereas as a parent, the Supreme Court has held over and over again that your familial bonds that you have with your biological family or adopted family are an extremely tight bond that cannot be pulled apart except under extreme circumstances. So that's a clear and convincing right given by the Constitution, even though the Constitution does not say anything about you have the right to be a parent to your child. It doesn't say that. But that is what has been found, that it does. In theory, in a roundabout way, it says that you have a right to be with your parents, but you do not have a right to be with a foster parent. So this judge here is saying Costanich doesn't apply because it applied only to foster parents. That case was so different because, yes, even though the same grounds were brought up in Costanich dealt with a foster parent and not with a biological parent.
Costanich deals with the underlying liberty interest of a 14th Amendment claim, which is the same
for foster
For
parents.
foster
though.
parents.
that is
Okay, so we're going to go ahead and skip through this argument with Costanich. Again, they're going. Two of these judges say for foster parents. It's a very big distinction. Again,
guardianship.
And guardianship, not natural parents. It seems to me that as early as the 1940s, the United States Supreme Court has held that there is an absolute liberty interest, a fundamental liberty interest that parents have in the care, custody, and control of their children. That's been on the books forever. I have a whole bunch of Supreme Court cases I could read from. That's just going to waste a lot of time. They have that fundamental constitutional right. And it cannot be impaired without due process of law.
And where the qualified immunity analysis and the clearly established law plays into this is, do we have case law that tells us that?
No. You've read Help versus Pelzer. There doesn't have to be case law. There can be other ways of showing that it's clearly established. Case law is not an absolute requirement.
So there's that hope. He's bringing in hope. It doesn't have to be clear case law. You can use other means to show that this prosecutor knew that it was bad to lie on the stand.
Have you read Hope versus Pelzer and all the other cases that talk about that?
Yes, Your Honor.
Okay, there does not have to be a case on all fours.
And again, Hope was decided in what, 1982? So by 2000 when this case started, and in 2016 when it's currently being heard on the Court of Appeals, Hope was clearly established. So, has already been on the books at this point for a long time.
You're correct.
Correct.
There does not have
Okay.
to be a case on all fours.
Right. What isn't clearly established here?
The fact that what Costanich says, what's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty.
So it has not been clearly established that you have a right not to have somebody lie about you. Look at this judge's face. Actually, I want to rewatch this as she makes this argument. I want to watch all these judges' faces here. So what is not been clearly established is that you have a right for you have a right that somebody can't fabricate, that a official state employee cannot make lies against you that then deprives you of your Fourth and 14th Amendment. The Fourth Amendment because she was taken into custody away from her parents, and the 14th Amendment, I can't remember exactly why they found, but again, we'll get there. But I do want to rewatch this part, so let's go back and let's look at the judges' faces. I was actually watching her. I was not watching the judges, but just look at this judge's face here. So this time I'm going to rewatch it and actually watch the judges.
Deliberately fabricated a case on all fours.
Right. What isn't clearly established here?
The fact that what Costanich says, what's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty interest, the same liberty interest.
But it's not the same liberty interest because this was a parental liberty interest.
Just like he's dumbfounded. He's just like, did you just make that argument? That okay? And I do love what they say here. Yeah, we'll continue.
It's a biological versus foster parent.
That's huge. That's gigantic in terms of what somebody could appreciate and understand. How in the world could a person in the position of, we have to take the facts as they're pleaded in the light most favorable, so, we're not trying the case. But how can a person in the shoes of your clients possibly
That's part of the video.
believe
That's not the
that
line
it was
of messaging.
appropriate to use perjury and false evidence in order to impair somebody's liberty interest in the continued care, custody, and control of that person's children. How could they possibly not be on notice that you can't do that?
I understand the.
How could that possibly be?
I understand the argument that it seems to be common sense and our ethical.
It's more than common
morals.
sense. It's statutes that prohibit perjury and submission of false evidence in court cases.
State statutes.
Are you telling me that a person in your client's shoes couldn't understand you can't commit perjury in a court proceeding in order to take somebody's children away?
Of course not, Your Honor.
Of course not.
Isn't the case over then?
And the case is over.
Because.
Costanich is distinguishable in my view. How in the world Costanich deals with a secondary care, foster care? That's a whole strange thing. It's not a person's real child.
Even if Costanich
And
is.
guardian's the same thing.
Even if Costanich is distinguishable, there is. Thus far, we have not been presented with any clearly established right that tells us that what our clients did, which is remove the children pursuant to a court order.
No, but what they're accused of doing and what the issue is here is committing perjury in a court to take away someone's children. And you just said that's obviously not okay to do.
According to our moral compass and our ethical guidelines, but what we're here to decide is
And the
the
law.
constitutionality of it, and we look to the courts.
You mean due process is somehow consistent with a government official introducing perjured testimony and false? How is that consistent? I mean, I hate to get pumped up about this, but I'm just staggered by the claim that people in the shoes of your clients wouldn't be on notice that you can't use perjury and false evidence to take away somebody's children. That to me is mind-boggling.
In criminal proceedings, we know this to be true because that.
No, at criminal proceedings, it's a court proceeding with a liberty interest, a fundamental liberty interest at stake.
And on the reverse side, the state.
And you're
also-
telling us that these officials who do this all the time couldn't be on notice that you can't commit perjury and put in false evidence.
I understand broadly the principle that common sense tells us that lying is wrong and lying to.
Yeah, but it's more than common sense. We're not using common sense. We're using the statutes, for example, against this kind of behavior.
I was not presented, I have not been seeing any federal law, case law, or law that tells me that in this situation that we were faced in, which is what we have
Well,
to look at.
say your clients hired 6 people to be actors and to go into court and say, we're neighbors and we saw all this terrible stuff. And then your clients presented those witnesses in court. You're telling me that they would have no reason to believe that you can't do that because there was no federal case that says you can't bring actors into court to swear falsely against somebody.
But again, here we're appealing to sort of a broader definition.
Good job. Ignore what he just said. There is no answer to that helps your case. So just move on. Don't respond. I mean, that's how do you answer that question without making the entire panel burst out laughing? I mean, these judges are doing amazing, and you can see her. I've been watching her throughout this because every time this judge over here, which I don't know his name, none of them have nameplates here, and I don't know the Ninth Circuit, especially not 5 years ago. But you see this lady here, she's looking over at him, and she's just smiling. She's laughing at his questions. She's laughing at the ridiculousness of these arguments, and they do know how this is going to go. Now, it is important to note that a dissent that I cannot find the opinion on, I cannot find the dissent opinion. She is the lone wolf to go with. She is the dissenting opinion on it. So we'll find out what the actual opinion was.
Definition of what is a clearly established right. I mean, we have to find the clearly established right in the context that our social workers were presented with, which was they were faced with a court order.
Again, I cannot even believe for a microsecond that if the caseworker wouldn't understand you can't lie and put in false evidence.
Let me ask the question a different way, counsel. Was there anything you know of that told social workers that they should lie and they should create false evidence in a court proceeding?
No, and of course, that is, we contend that that's not what happened here.
I understand. And look,
Yeah, we're stuck with the facts, and the light most favor.
And to be clear, we are only speaking that
Right.
we accept the pleadings as alleged. We are not saying any of this is true. I want to be very clear about that. But
Right.
that's what we're dealing with right now. Is there anything? I mean, look, you've got your clients. You're doing your best to represent them here. But from our perspective, you see where we're coming from here. So help us. Okay, we've talked about Costanich, and we've said that case there's some language in there which I understand what you're pointing to. I got you. But as Judge Friedland and Judge Trotta both said, it also does have a different interest. So is there any case besides Costanich that you can point to and say, here's Ninth Circuit, this is the answer?
So this is awesome. He's giving her a branch. She's to hold on to, so she can keep her case going, and she misses.
Well, what I would contend, Your Honor, is that was plaintiff's burden to do when it came to
No,
call.
I understand that's your argument, but just for your sake, because you reached to Costanich, which if I were in your shoes, I'd be reaching for it too, as hard as I possibly can. Is there another case? You got one hand kind of on the ledge here with Costanich. Is there another hand you can grab another Ninth Circuit case where you've got a firm grasp? You can say, see, I've got it.
In terms of another Ninth Circuit case that instructs social workers to lie and
Or at least sets a time period. At least sets a time period that says, as of this date, you can't do this anymore.
other than Costanich, Your Honor, I do not have any such case in front of me.
As a matter of fact, Snell precedes all of this, and we have cited Snell with approval on many occasions.
I understand
So we'll
that
talk
it's
about
not
Snell
case
in the
based
opinion.
on-
And we've embraced Snell in our published opinions.
In the context of criminal proceedings, yes, that is true.
Snell wasn't a criminal proceeding.
I believe Snell involved a criminal proceeding, an affidavit for a warrant. I believe was the
Okay,
was
we're
the
going to
underlying
skip.
issue.
Nothing other than Costanich. Now, they're going to come up and they're going to talk about the Green case, Green versus Camreta. What's your response? And look, and I will acknowledge, our case law is not entirely clear on this, okay? So I don't fault you for having to dance around these two cases. But Green, what's your response to Green?
Green does not as clearly establish the law as it was in the year 2000. Green was decided in 2009, involving conduct in 2003.
But all those cases talk about conduct that was previous to the conduct in this case. They referred to cases that referred to conduct that was earlier than what happened in this case.
Correct, but again, in the context of criminal proceedings.
But Green cites them as establishing a principle beyond criminal, right?
Right.
It does, and one thing that we read in Costanich, and I understand we're sort of beyond that, but there is a difference between civil child abuse proceedings and criminal proceedings.
But doesn't Green stand for the proposition that that's not true?
Even if it did, again, it is post-conduct authority that our clients would not have been aware of. And
All
Your
right,
Honor's
let's just get into the opinion. She continues dancing around. She only has a couple more minutes, and then it's his turn to speak. Oh, wow, she continues for another 5 minutes there. And then she comes back up and speaks for a couple more minutes. At the end, nothing new and substantive, nothing new and huge that we're going to deal with that we can't read in this opinion. So this is an appeal argued, filed 2017. The opinion is by Judge Trott, who I don't know the different judges. I'm going to assume that she is Michelle Friedland. This is California, so if I got this name pointing out which one is Michelle incorrect, I apologize. I meant no disrespect, Your Honor. But I'm going to assume for the purposes of this that's Michelle. And I don't know who the other two are, which one is Trott and which one is Owen. But the opinion was written by one of these two, according to the evidence I have in front of me. Again, one of them may be Michelle. I don't know. So this is a summary written by their staff. We're going to skip it. Pursuant to an order of the Superior Court of Orange County, California, arising from acrimonious juvenile dependency proceedings, She lost custody of her minor children, Presley and Kendall. In this civil rights action brought under 1983, Hardwick sued the county and employees of its social services agency. She contends that the social worker employee, acting under color of state law, maliciously used perjured testimony and fabricated evidence to secure her removal from her mother, and that this abuse of state power violated her 4th and 14th Amendment constitutional rights to her familial relationship with her mother. So the 14th deals with her familial relationship. 4th Amendment right is going to deal with being detained by the state. She was taken away. She was actually put in foster care. She wasn't even put with family. In a motion for summary judgment, the individual defendants unsuccessfully raised absolute and qualified immunity as shields against this action. They appealed, claiming, among other things, that the law Presley accuses them of violating was not clearly established at the time their allegedly wrongdoing conduct occurred, and that is Harlow versus Fitzgerald, which we looked at that other case. So we've looked at both of these cases, actually, Nixon versus Fitzgerald, which is absolute immunity and qualified immunity. So we'll skip those. Background: this lawsuit is not the first stemming from the implosion of Presley's family. Her mother, Deanna, successfully sued some of the social workers in state court for the same conduct and pursuant to the same legal theory, and she recovered a sizable sum in damages plus attorney's fees. So she was actually awarded by the jury $85 million. Then that was later reduced down to $10 million, just $10 million. Remanding the trial court with directions to strike injunctive relief from the judgment and affirming judgment in all other aspects. To quote the California Court of Appeal, in this case, the jury specifically concluded that Vreeken and Wojak lied, falsified evidence, and suppressed exculpatory evidence, all of which was material to the dependency court's decision to deprive Hardwick of custody, and that they did so with malice. These findings are clearly sufficient to satisfy the Supreme Court's definition of circumstances in which qualified immunity would not be available. So, the Court of Appeals also acknowledged the defendant's collective admission on appeal that the evidence was sufficient to demonstrate the social workers committed egregious acts of misconduct in the dependency case. The court said, as the county concedes, Fogarty demonstrated, if the testimony is to be believed, that in this one instance, social workers lied and fabricated evidence in connection with the dependency proceedings relating to her children. Scope and her standard of review. This is going to say that this is a interlocutory appeal, so they're only going to discuss immunity from the lawsuit, qualified and stuff, and they're going to hear things de novo, which means on its own substance. They don't have to take into the previous court's decisions into what they find. They start from the beginning. I apologize. So absolute immunity. Absolute immunity from private lawsuits covers the official activities of social workers only when they perform quasi-prosecutorial or quasi-judicial functions in juvenile dependency court. The factor determines whether absolute immunity covers a social worker's activity or function under scrutiny is whether it was investigative or administrative on one hand, or part and parcel of presenting the state's case as a generic advocate on the other. Absolute immunity is only available if it falls under the prosecutorial conduct. Here, Presley tells us that the social workers, so Presley again is the child. By the time that this happened, she was no longer a child. So Presley is the child, let's keep that in mind. The allegedly false statements and omissions made in defendant's court reports continuously submitted by them through the termination of dependency proceedings. Statements made by the defendant social workers during an off-the-record discussion and during an on-the-record discussion that same day, where the social workers allegedly lied, but not while under oath, to the commissioner overseeing the dependency proceeding, triggered her seizure, which when I first read this, I read medical seizure. No, her seizure. She was seized from her parents. The alleged fabrication of evidence throughout the dependency proceedings and repeated suppression of exculpatory evidence in defendants' written court reports and defendants' corrupt recommendations that Presley continued to be detained even though defendants allegedly knew they were lying to the court about the basis for the initial seizure and subsequent detention. So not only did you lie to begin with, and you knew you were lying, and you continued to lie about it. So defendant's actions Presley intends to prove as fault. We're not going to talk about what the actual lies were. It's not important. On the basis of this alleged misinformation, the dependency court concluded that Deanna was using her children. Accordingly, the court immediately removed the girls from her custody and turned them over to the SSA and the defendants. Presley and her sister were sent to the Orange County Children's Home. On February 23, 2000, the court authorized the return of the girls to their mother's custody, but the social workers refused and placed them instead in foster care, where they remained until May 2000. I thought I read somewhere else that it was for 6.5 years, not 6 months. But okay, 6 months. But still, doesn't matter if it's 1 day. Okay. Presley's complaint targets conduct well outside of the social worker's legitimate role as a quasi-prosecutorial advocate in presenting the case. Our opinion disposes of this issue. We held in Beltran that social workers may have absolute immunity when they are discharging functions that are critical to the judicial process itself. But they are not entitled to absolute immunity from claims they fabricated evidence during an investigation or made false statements in a dependency petition affidavit they signed under penalty of perjury, because such actions aren't similar to discretionary decisions about whether to prosecute. So you didn't act as a prosecutor when you decided to fabricate this evidence. You were acting as a investigator. It's a qualified immunity. Her constitutional rights. Again, this is going to talk about the constitutional rights. For the purposes of this video, I am going to skip this part of the opinion and just state that you have constitutional rights as a child to live with your parents unless there is clear and convincing evidence that you are in danger or other subsets of it. So, clearly established. This exacting standard gives governmental officials breathing room to make reasonable mistaken judgments by protecting all but the plainly incompetent who knowingly violate the law. That is the most important part of this entire sentence. But the plainly incompetent or those who knowingly violate the law. So in this case, they are alleging that she created evidence out of nothing. And so that is violating the law. This is not to say an official action is protected by qualified immunity unless the very action in question has previously been held unlawful. But it is to say that in light of pre-existing law, unlawfulness must be apparent. Hope versus Pelzer. So Hope states that in the light of without pre-existing law, the unlawfulness must be apparent. It must be clear on its face and so egregious to reach the standard of Hope that nobody could claim it met it. Just wait. So this continues on the salacious questions. To buttress this conclusion that a reasonable person would have known the unconstitutionality of the disputed practice, the court also relied on a relevant shackling regulation promulgated by the Alabama Department of Corrections and United States Department of Justice report warning the ADOC of the unconstitutionality of the disputed practice. So even though there wasn't, in this case that they're citing here, even though there wasn't something that says this is bad in case law, they were warned that it was bad by the Department of Justice. So this talks about Green. We're going to go ahead and ignore a lot of this. The defendants contend that Green is irrelevant because the offending affidavit in this case was filed, but it talks about other cases, so that's what they talked about there. Now here, my favorite quote from a court of appeals that I have ever read before. No official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct at the center of this case violated both state and federal law. No official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct at the center of this case violated both state and federal law. So you as a Child Protective Service employee should know that what you are doing when you commit perjury in a court of law is bad. Best quote ever. And then here they quote some of that, those arguments that you heard. Are you telling me that the person in your client's shoes could not understand you cannot commit perjury? And she said, of course not. So that should be the end of the discussion on if it falls under hope, right? But it wasn't. They had to continue. But they continue here with different things. And then here's important as well. Government, So California, where this took place in 1995, the state of California enacted this bill. The Civil Immunity of Juvenile Court Social Workers, Child Protective Workers, and other public employees authorized to initiate or conduct investigations or proceedings pursuant to shall not extend to any of the following if committed with malice: perjury, fabrication of evidence, failure to disclose known exculpatory evidence, obtaining testimony by duress, fraud, and undue influence. So if you perjure yourself, which they say that they did, you fabricated evidence, which again they claim that they did, and you don't disclose exculpatory evidence that you know about, and again that's a claim that that Presley says that the child protective worker does, then under California law they waive all of your immunities as a prosecutor. They waive it. They just say, you know what, we're done. Okay? Why would they do this? Section 820.21 did not come about because of someone's academic concern about wrongful conduct by social workers in connection with dependency proceedings. The bill was the direct result of a notorious case, James W. versus Super, in 1993. The trial court granted absolute immunity for egregious acts resulting in the removal of a child from her family. Although the trial court was reversed on appeal, the issue generated statewide concern. So what they're saying here is that this bill that makes this, that waives this immunity for the for the child social worker happened because this other case, not just out of thin air, somebody just didn't create this bill out of thin air. No, they did it in response to another case where a social worker's behavior was so horrible that it received national and state headlines, and it was just covered so widely, and it was so people were so horrified by the case. Just as the court in Hope used ADOC regulation and DOJ report to support its conclusion that the officials were on fair notice of the wrongfulness of their conduct, here a pertinent state statute warns defendants in unmistakable language of the personal consequences of lies, perjury, and deception, the loss of immunity for such conduct. Furthermore, the statute focuses on behavior designed wrongfully to affect dependency proceedings in court, the citadel of due process. We believe this is the kind of case the Supreme Court had in mind in Hope when it talked about conduct that's so clearly and obviously wrong that the conduct itself unmistakably should have provided defendants with some notice their alleged conduct violated their target's constitutional rights. So again, I phrase it as the common sense doctrine of qualified immunity. Courts won't call it the common sense doctrine because it's far above common sense. But it should be just common sense. It should be lowered to that standard. They have not lowered it there. Here, they are saying that there is a state law that says if you commit these acts, we will not protect you in a lawsuit. You waive all these immunities because of your behavior being so atrocious. And that was passed in 1995. And so because of that passing and this case, the other case receiving so many news articles about it, that and the anger that people felt, that it's impossible for the social worker to not know it existed. And I apologize if you hear my dog in the background. He's chewing on something. I don't know what. I can't see him. We cannot, try as we might, we cannot conceive of circumstances which social workers would not know and understand that they could not use criminal behavior in any court setting to interfere with the person's fundamental constitutional liberty interests. Their deportment, as alleged by Presley, could not have reasonably been thought consistent with the rights they are alleged to have violated in Anderson U.S. Supreme Court. Costanich. We're going to skip Costanich because, again, it talks about the rights of a foster parent being violated or a child being removed from a foster parent or a guardian instead of a natural parent. It does not apply. The court is very clear that this does not apply in this case. Presley has produced more than sufficient admissible evidence to create a genuine dispute as to whether her removal from her mother's custody violated her constitutional rights. Also, the defendant's case for qualified immunity from these charges is not supported by the law or the record. Accordingly, the matter shall proceed in the district court to a final judgment. Now, sad news on this front. The case did go in front of a jury. It seems that the judge, or evidence was presented that the judge said was bad, so he just said, hey, ignore everything you just heard, but the jury, for reasons unknown, found not guilty. And so they've been talking about an appeal since that decision in 2018, and it has not happened yet. So I doubt that it's going to continue any further. Again, this is just another of those cases where we take a look at qualified immunity, prosecutorial immunity, and yes, even using hope as case law, which we rarely get to see in a court of appeals opinion. We rarely see them, and it's so awesome that they pulled hope into a child protective case about qualified immunity. I mean, it's just so awesome that they will use hope. Again, this case was decided in 2017, and so the Court of Appeals, that shows you that Court of Appeals knows about hope. They know it's there. They are just extremely reluctant to ever apply it, which I do believe is the most horrible part about it. So this was a case of Hardwick versus County of Orange and Vreeken, the social workers. Oh, also important to note, these two social workers, as of 2018, were both still employed by the state as social workers. They knowingly fabricated evidence, and the state did not fire them for it. So, alright, there you guys go. Thank you for joining me. Have a fantastic night.